Okay, so this is Meet Up Speak Up. My name is Jacqueline Sprouse. It's kind of sunny in here, so you might can't see me. You might can see different phrases of me, everything of my mustache or whatever. But it is 8:25, and it is February 14, 2023. Now you will hear me do this every time I come into a video. Well, I also do it on record. Every time I date time and proceed to give you the year, okay? Because this is very essential when it comes to documents or things that you're saying on the video. And people come back with all these other insinuations, and you can just pull it up. Say, oh, nope, I did it on February the 14th of 2023 at 8:25, okay? So my whole point is coming in is break down these sessions, so it won't be longevity. So I'm gonna try to keep it under 5 minutes. Okay. So what I'm telling you right now is that when we went to the last session, and this is about 36th District Court, how dysfunctional the actual settings. Now, it may not be dysfunctional. They want to be dysfunctional. Some people pretend like they don't know something with certain people because they don't want to do it, or they want that person not to do something where it's representing themselves in court. So I'm aware of that, and when I say the court needs investigation, it needs investigation because of that. If you're pretending that you don't know how to do it because you want to make more um, um, you want to make me feel more not uh, I guess inferior. I should use the word inferior. You want me to make me feel inferior, that I don't know what I'm doing. I know what I'm doing. Okay. Even if I go to a process, I will pull up I studied paralegal. I would pull up different laws, different settings, different instructions. So when I put in the motion to dismiss, basically I put it in for a purpose, and that is the document, the complaint that was presented to me was not presented to me right, but also I have the evidence that what he's saying in his complaint is not right. Okay, so all that was submitted to the court. Okay, so as they pretending like none of that was submitted to the court, it was. Okay, but as of today of February 14th of 2023, I haven't received any documents back from the court from the case that we did a Zoom on February the 9th of 2023. I'm just letting the video know this so I can put it on documentation. So when they go to hollering that they sent these documents back out and my next steps and the reason why I didn't do the 7 days and the reason why I didn't do the 21 days, stuff like that. Okay, so and I understand that a lot of people don't understand what's going on in the court system. They don't understand the court system. They just go and get a lawyer and go like that. I don't do that. I did that once, okay? And this is the reason why I really don't trust attorneys, even from this situation, okay? But I'm not going to get into that later. My whole purpose is to come back here and let you know that none of the documents from the case that was done on the 9th has been submitted to me, okay? And to let you know, this kind of like what is a complaint, okay? A complaint, you can do a complaint at work. Somebody write a complaint up on you. It's just a bunch of words put on a document that says you've done something that did not reside with their contract. That's basically what a complaint is, okay? So if I write a complaint and say, David didn't take out the trash, okay? And David come back and David says, no, I dispute that complaint because I did take out the trash. And David shows proof that he took out that trash, like a time card. He snapped when he took out the trash, okay? That's his proof against the person allegations that they're putting on the documentation. And then I asked that person who put that documentation down, where's your proof? And you have no proof. Or if you have proof, it's not submitted. So I said, submit your proof. And he submitted a documentation showing that he served the document. Okay? So let's go over it again. If David had a complaint against him, David comes in, show proof from his time card he punched out when he took the trash out. That's his proof. Because he punched out legal time card, okay? Showing that he left that building at that point in time to take out that trash. And when he came back in, he punched the clock again. That tells you he came back in during that time. So he has more proof. We don't have the visual site, but we have the document site, okay, that he did it, okay? Now, we have another person, the person who wrote the complaint. We asked them, bring in the information that you're complaining about. The person could be complaining about the same thing. We're going to use the garbage situation. Well, show me how he didn't take out the garbage. And they send a documentation of the summary where the complaint was served and the proof of service. And that's the evidence. No. You have to show me how you came to that reality that David didn't take out the trash. Okay? So you have to show me you were standing there, the trash was still there. The trash is still there today. You took a picture of it. Trash is still there. You have to show me proof of how you still want this complaint to go through. And this is what happened in my case. And it happened, we're in a court in front of a judge, and I'm saying beyond the proof of service, beyond the summons he did not send with the complaint itself is not true. So I upload all these documents to show it's not true, because $1,885 is nowhere on these documents. And this is what he's suing me for, $1,885. He needs to show me where he's getting that money from, because it's not on none of my documents. Now, it was implemented on an invoice, but that was an invoice 30 days after the contract was paid in full. Now, if he said, well, that should be the documentation of it, that should be my evidence. Well, then, if it was 30 days after the contract was paid in full, that means you have to have another contract. Because that means that that contract that you created for the $1,885 was signed by me. And it was a different contract, because I already paid in full the contract we made an agreement on with the amount of money that was put on the first contract. When you can't show a second contract or any evidence of where, just like the garbage, where the garbage is still existing, then therefore you have no case. You have words, but you have no case. And this is the same scenario I'm talking about in my case. Okay? So that's what I came back on here to talk about, because I didn't want to get anyone's misunderstanding of what actually this case is about. That's all this case is about. The judge ruled for the attorney when he didn't submit any documents at first with the complaint, and then he didn't submit the evidence that he had in the complaint. Although I submitted the documents and a picture showing that he left it on the front door of my business, and the contracts that I'm showing you on video right now, I submitted all that evidence. And I was being denied for the motion to dismiss. Now, the motion to dismiss to put in is to present your evidence. Once they hear you at the motion to dismiss, is to just to start off. Your Honor, at this point in time, he did not submit a proof of service, nor did he submit a summons with the accurate dates on it, with a signed that's supposed to be presented with a complaint. He did not submit a proof of service to me, because he's saying that he submitted to me by hand. Okay? So if you submitted to me by hand, then you would have that accurate date that you submitted me them documents. I didn't receive none of that. I received that on February the 2nd when the court told him to send it to me. Not when he actually presented the document of a complaint on the door frame of my business. Although that was being said, I also said, Your Honor, at this point in time, I have evidence that the complaint is not true. She bypassed all of that and was like, oh, we talking about the default. You set aside, Miss Rose. We want to know where your merit is. Like, I don't know what merit is. Okay? And I think that's the whole lingo they're talking about, because of the simple fact that she thought I really didn't know what merit is. Okay? Merit is of your case. Let me explain what merit is. Merit is evidence. That's it. And I'm steady saying, listen to what I'm saying. I'm steady saying, well, Your Honor, besides the documents, okay, he just sent the documents. Your Honor, I haven't had time to look over the documents because of the simple fact he just sent them. So, and you just told him to send them. So we in a quarter session, okay, I need time. That's all I said. I need time. Oh, no, we ain't going to get no time. We ain't going to do no time. We ain't going to do no time. Okay. I could have had 30 minutes to go over the documents and then order the court to pull up the evidence that I had already sent in. But instead, she took it to a point where it was, oh no, I said, I need time. Maybe I need to consult. I see you saying that every person who have a business should have a business attorney. Although you didn't say that to me. And it is put on my document continuously that he served my business. So are you being biased towards me while you being, objective with everybody else? Because everybody else, you're telling them that if it's part of a business, you have to have a business lawyer. You can't represent yourself. This is what the judge is telling everybody else that's coming in the courtroom, trying to represent themselves through their business. Okay? But I was given a special little, oh, no, we can't prolong this. I said, Your Honor, this was done in my business. He presented my business, not me. And I have proof of that. I have the evidence. Oh, no, we not going to go through all this. No, it's not your business. It's not your business. It's you. Okay, if it's me, the whole point is I still would need time because he just sent me the documents to go over the documents. What you do when someone sent, let me kind of break this down. When someone sends you the evidence, okay, what your preference is to take in the evidence, look at the evidence, and say that he sent it on, I presented this document on the 22nd of 2022, okay? So I'm saying that I gave you this document in your hand on October the 22nd of 2022, when I know I didn't give it to you. So it's up to you to say, okay, let's get some laws going on this, and we can go to the Michigan Compel Laws. And Michigan Compel Laws is, it's not like you're going by ordinance. You're going by the law. So you go to Michigan Compel Laws, okay? Or the Michigan Court Rules, okay? So under the Michigan Court Rules, under 504, if he present evidence, whereas he did not actually give me that document personally, you put down the MCR numbers, how you disputed it. And then you put down articles from the Michigan Compel Laws to dispute his complaint. Okay? So under his complaint, under 211.6, whereas this complaint it could be challenged. And then when you say that under that law, okay, versus under the dates and times and everything under that law, you put that in, and then you go back to court to dispute his documentations or what he put in. Of course, I couldn't do that because he never put in no evidence for the $1,885. So I could never do that. So I'm asking the judge, Your Honor, he did not put in any evidence. We got a motion to dismiss. Motion to dismiss brings you in so you can discuss all that. So you can say, Your Honor, I would need from him the evidence of the $1,885. I will also need where he's claiming that the down payment was $6,885. I would need also that document. I would need the document of the contract that he's claiming here, because this is the only contract he's claiming. And this contract that I submitted to the court is basically disputing his contract, because what my contract is saying is disputing his contract. I also see that it was spotted out here. I want to know who spotted that out, and I want a documentation of why did they spot it out and what was there in it. See, you go through challenging his complaint with your evidence. That didn't ever happen, because the judge chose to take his complaint, although I'm motioning after motioning after motioning, trying to get my information in there, sent the evidence to the court in their evidence line on their website. Go to their website, 36th District Court. It has an evidence piece up there, and it says you can implement the evidence up to 2 days, or the request for a adjournment up to two days. Now, I implement the evidence online, as well as I bring the evidence into court after calling them, and she told me they may not have it in time enough for the court. So I physically took the evidence in there, and she stamped the document. Okay? Now, you got to look at a point here. This is coming from October of 2022, where I put in a motion for the dismiss on November the 8th of 2022. Never heard. Now, they had all the way from November the 9th all the way to December the 8th to put that motion in, okay, to give me a right to be heard on that motion. Instead, they denied the motion before the 28th, because I got before December the 8th, they denied that motion. They already had put things in process, okay? So then they put the date that the motion was being denied on the 12th of the 8th of 2022, because October 2023 haven't gotten here yet. So they put that in on the 12th of the 8th of 2022, saying the motion had been denied. Implemented it into the docket in the court where the clerk is. Clerk files, that's where you get all your files from. It's from the clerk. Just like when you go to the medical assistant front office, you get all your files. Okay, that's what the clerk does, okay? So the clerk got all these files here, and if one only file that's in there, my file of a docket, is motion to dismiss is denied. Not motion to dismiss is denied pre-trial default because you didn't show up. Not that in the file. Not nothing of the pre-trial, including with the motion to dismiss. Just the motion to dismiss. I asked them where the order is. You got the motion to dismiss, but you have no order. Where's the order? The judge got to tell me why he was dismissing his own rules. The rules of the MCR and the rules of the Michigan Compel Law. You have to tell me these are his laws. These are laws that was created by the people put in here, and it becomes the judge's laws. Why are you dismissing your own laws? He got to give me an order for that. Oh, he said he ain't giving no order. Judges do that. They don't give no order. This is the deputy clerk telling me this. Oh, he said he don't give no order. I said, well, that don't make any sense. I said, normally if somebody is disputing, this is the judge that's saying that he's denying, and he has to give you an order. He can't just, this should be on video. Because I was very loud about this. This is the reason why they had to call. I told them to call for a supervisor. Because I said, this don't make any sense. Okay, I've been waiting on this motion to dismiss all this time. And all of a sudden, bypass dates. It comes back on the 12th or the 8th. Now, remember when we started with this motion, the motion started on the November 9th, 2022. You waited 30 whole days, over 30 days, okay, because it's one day over 30 days, because December going, 31 days, go to December, but the thing about it starts from the 9th, so you waited whole 31 days, and then send me a document when y'all supposed to have been closed. The court is supposed to have been closed, is what they told me, on implement a document in the docket on the 12th or the 8th of 2022 on denial of the motion to dismiss. That's it. So all they put in that document. I asked them, where the order? Okay? Now here's how they're going to really call out themselves. Because once you put the 12th or the 8th of 2022, and then you deny a document, and then you say it's an order. Well, that order has got to be with that 12th or the 8th of 2022. The order cannot be, oh, she prolonged it. No. This is what the attorney was trying. That's why he kept saying on the record, I prolonged it. And you can prove that. I'm not going to go into that right now. You can prove it how it wasn't prolonged by me. But the whole point is that that's what they're trying to pretend, like it was prolonged. The decision was made on the 12th or the 8th of 2022. Okay? If the decision was made on the 12th or the 8th of 2022, I should have been involved in the system. I should have been involved. If it was an in-court session of a hearing, then I should have been sent out the documentation. If it was a Zoom hearing, I could have been sent it by email. But the whole point is, every data got to check out. These Zooms are being done by cloud, okay? These Zooms is not being done whereas, oh, I can do a personal Zoom, because a court is not a personal Zoom. A court is a government Zoom. And if you've done it by a personal Zoom, then you are doing it wrong. Anybody who get a personal Zoom from a government official, reject it, because the whole purpose of getting them government Zooms is to prove they have actually sat in a meeting, in a session with you. Anything that comes across personal, I would reject it. Unless it's a personal, you and your friend, you and your cousin, something like that. But if it's from a government official, okay, the Zooms are being done for an important matter. That means you can go back to that Zoom. You can pull up that Zoom. You got documentations for that Zoom. So you can be able to prove that you actually had the Zoom. Okay? So, that's what I'm actually letting this video know at this point in time. Okay? So, this is all I wanted to say. I'm going to keep it under a certain amount of time because I know I'm just talking right now and I don't want to talk too much. So, this is Jacqueline Sprouse. Meet Up, Speak Up.